Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away, potentially, no guarantees. And today I'm finishing my series on the 4 elements of malpractice. We're going to discuss the damages element today. As a reminder, legal malpractice claims have 4 elements in New York: privity, the attorney-client relationship, number 1; negligence, a breach of the standard of care, number 2; proximate cause is number 3; and then actual and ascertainable damages. In New York, only pecuniary loss is available. It has to be actual, ascertainable, non-speculative. There were some interesting cases coming out of the Fourth Department where emotional distress, loss of liberty, things like that could be recoverable, and the Court of Appeals unequivocally rejected that. And in certain other states, emotional distress and wrongful incarceration, things like that, are recoverable. In New York, it is pecuniary damages only, so it's only dollar damages. There's a split in the circuits between collectability and whether the underlying judgment at issue is collectible. It can be a defense if or it's incorporated as an element in the damages element, depending on which department you're in. But either way, if the underlying judgment or whatever it was valueless, then you won't be able to establish actual ascertainable damages. Lost profits, business speculation, all that stuff is generally rejected. I have a scenario. I had a case where my defendant firm attached their client purchaser's signature to an earlier draft of the contract, and it was a $5 million mistake. It was bad. The interesting thing here was, the client attorneys, I think rightfully so, they recognized they made a big mistake. It was an administrative mistake, unfortunately, not something a lawyer even did, but ultimately they were responsible. And, they had already apologized, and they sort of wanted to concede liability. And, of course, we didn't want to concede liability. We didn't even want to concede the negligence element. And as it turned out, now this was back, 2012, 2013, something like that, as the economy was picking up, as it turned out, the huge contract issue actually didn't amount to any damage, because between the sale and the lawsuit, the value of the home had increased exponentially. And so we were able to show with an expert that there was no damage, no actual and ascertainable damages, despite the fact that we admittedly used the wrong contract and had hindered the client seller greatly at that point. So again, in New York, you have to actual ascertainable damages, and the collectability issue comes into play because the legal malpractice claim is to make the client whole. So if the underlying property, if the underlying judgment was valueless, then they can't show actual and ascertainable damages. Some ethics considerations with the damages element. Of course, in New York, we have interest available. That 9% is an incredible investment and comes into play. Attorney's fees to cure malpractice are not available in New York, typically. Some jurisdictions do allow fees to cure, but not prosecute. And the accrual date of when the malpractice actually occurred will often be a major source of contention to determine, because again, that 9% really can add up quickly. The non-pecuniary damages, that really impacts our ethical obligations. While it's not recoverable in a legal malpractice claim, reputational harm, certainly loss of liberty, time wrongfully incarcerated, emotional damages, those are damages, right? They're just not, they're not recoverable. A court can't award dollars for those in a legal malpractice claim. But again, that's a huge failure of our ethical obligations to our clients. So you, of course, need to keep that in mind. They're not recoverable, but they really are damages. These sorts of damages tend to come up in very sensitive cases anyway: matrimonial, family law cases, criminal law cases. Again, dealing with sensitive clients, incompetent clients, incapacitated clients. That's where, when you have a particularly vulnerable client, that's where the non-pecuniary damages tend to appear the most, and definitely need to be thought of and addressed early on. Again, non-pecuniary loss is not recoverable, but those damages do exist. To wrap up, our 4 days of legal malpractice elements and ethics, there's a clear overlap between the ethics, our ethical rules, and the legal malpractice claims. Each aspect of the representation presents risks and challenges to the attorney. You have to know the rules of New York and whatever jurisdiction you're in. And your best risk avoidance, risk mitigation tool is contemporaneous communications in writing. Email just cannot be overlooked. And to shoot a quick email out with an update, to follow up with a phone call, to follow up with a written report, whatever, to provide the client with the most recent information you can, especially settlement communications, but really any development, just to preserve that in writing is really a best practice that shouldn't be overlooked. It protects you, but it also protects the client and helps you meet your ethical obligations. That's been our point one for the day. Thank you so much for joining us.